Good morning, everybody, and welcome to the Duke Journal of Constitutional Law and Public Policy Symposium. My name is Joseph Blocher. I am the faculty advisor of the journal. I teach constitutional law, capital punishment, property, and some other courses here. And I just wanted to say a very quick welcome to all of you who've come to be here, and a very special thank you to the student editors, especially Matthew Sloan, who has done extraordinary work to pull this whole event together to bring you all here. I know the other editors are going to do great work on the issue of the journal that contains your fantastic articles. When the students came to me last year with the idea for this topic, we thought, well, we'll just aim high. We'll try to get like all the best people and all the best topics, and it worked out. We've got even better people than we'd expected. So special thanks to them, special welcome to you, and special regrets from me. I'm going to be in and out for the day. As some of you know, my wife and I have a newborn at home and a toddler, so I'm going to drink as much coffee as I can, but I also have to go home and take care of that. And with that, let me turn things over to Matthew.
Good morning, everyone. As Professor Blocher said, my name is Matthew Sloan, and I am the Special Projects Editor of the Duke Journal of Constitutional Law and Public Policy. And on behalf of the entire journal, I would like to welcome you all to our Spring 2016 Symposium on the American death penalty after Glossip. Before we begin, there are several individuals I would like to thank. First and foremost, thank you to our panelists and moderators who have come from as near as this law school and as far away as California to be here today. It's been a pleasure to work with all of you over the last several weeks, and we're excited to finally see you all in action. To those authors who could not be here today, thank you for your hard work and contributions to this very significant discourse. One of those individuals is John Bloom, who was actually a professor of mine at Cornell University and whose course which I took senior year on the death penalty, was a major catalyst in our choosing of this topic. To Professor Blocher, where is he? There he is. Thank you so much for your ongoing assistance and guidance throughout this process. Even while taking care of a newborn child over the last few weeks, you've still, by some miracle or feat of strength, found time to respond to all of my emails and play an active role in this process. So for that, we are very grateful. I'd like to thank our journal administrators, Melanie Dunshee and Christy Compost, for keeping us organized, aware, and on track throughout this process. I'd like to thank our editor-in-chief, Jonathan Robe, and our managing editor, Aaron Malone-Smola, for their constant encouragement and positive feedback. And lastly, I would like to thank our sponsors, Quarles and Brady, and the Eighth Amendment Project for their generous support of today's event. So at this point, I would like to introduce a very special guest of ours. In May of 2014, Henderson Hill, veteran litigator and a lifelong anti-death penalty advocate, was hired as the executive director of the Eighth Amendment Project. A proven and respected leader in the legal field, both nationally and in his home state of North Carolina, Hill has brought more than 2 decades of experience in capital defense and civil rights litigation. Most recently, Hill served as the executive director of the Federal Defenders of Western North Carolina, where he led a team of 35 attorneys and staff in providing legal representation for indigent defendants. Prior to the Federal Defenders, Hill was a partner in litigation practice for more than a decade at Ferguson Stein Chambers, and has been regarded as one of the finest trial attorneys in the country, and has been recognized as a fellow of the American College of Trial Lawyers. Similarly, many consider Hill a pillar of his community here in North Carolina. In 1995, he founded the Center for Death Penalty Litigation here in Durham, and now serves on the board of directors of the center, which has grown into a staff of more than 20 individuals. Hill's accolades, community engagements, and professional affiliations are numerous. Currently, he serves on the board of directors of Supportive Housing Communities in Charlotte and on the advisory board of Common Justice in Brooklyn, New York. Hill is also the founder of the Neighborhood Advocacy Center in Charlotte and of the Charlotte Coalition for Community Justice. Throughout his career, Hill has lectured widely on the death penalty, criminal defense, and restorative justice. He has served as an adjunct professor and lecturer at the University of North Carolina and the Duke School of Law. Hill is a graduate of Harvard Law School and received his Bachelor of Arts degree from Lehman College, City University of New York. So without further ado, I would like to introduce Henderson Hill.
Thank you, Matthew. Good morning. Well, thanks to the Duke Law Journal, the Duke Journal for Constitutional Law. I think it's an incredible time to hold this symposium. I guess at the very beginning we should acknowledge and note that last week Justice Antonin Scalia died, passed after 30 years of service on the court. And it's hard to imagine a discussion about the Constitution or about the court without thinking of Scalia's presence in this field and the space that he's occupied in the country's consciousness about all things legal. And so at this symposium, I think it's entirely appropriate to just sort of pause and take a moment to note that passing. You know, when I think about Scalia and I think about our subject, the death penalty, it struck me that, you know, shortly after the beginning of the term, you know, he made a comment, and he repeated this comment, that he thought that the current court had 4 votes to abolish the death penalty. And twice he mused that he would not be surprised if this court were to find the death penalty unconstitutional. And for many of us, those were remarkable musings. And if you take, you know, those sort of informal observations from a figure of his stature, and you combine that with the dissent in Glossip, you know, we're living in a remarkable time. You know, folks have talked about Glossip and Justice Breyer's dissent in similar tones with the Goldberg dissent in Rudolph, you know, 50 years ago. You know, there's a remarkable difference between those two dissents. You know, Goldberg, you know, had a very limited scope, and he raised the question, you know, whether the American death penalty with respect to rape was consistent with American or international standards and practice. Yeah, I'm blown away when I read Breyer's dissent in Glossip. You know, not only by length, that it is 40 pages and appendices out to here, but it's more than what other justices in other occasions have written to enter that pause button and to cause the country and our community to reflect on this policy. I mean, it was a direct challenge. I mean, it was a comprehensive review of the real-world difficulties with the death penalty. And it was so nuanced. I mean, I have spent the last, you know, 25 years thinking about this subject, and I read that opinion, and I thought, this was a justice that gets it. Yeah, so it's remarkable that the journal would hold the symposium now. I think it's a real service to do. I think it's an important service to the profession and to the bar and to the academy, and I thank the journal for that. We're living in a remarkable time. A few weeks ago, I was in the General Assembly in Delaware, and the week before I was there, they had passed a resolution apologizing for slavery. And Delaware, a small state, was one of the last to abolish slavery. And it took them a long time to apologize, but the apology came. And then the next week, we're in the General Assembly, and they're debating abolition of the death penalty. The Senate in Delaware had voted in favor of abolition for 2 sessions running. And just the week before, the House had released it from the committee, and on that date, we fell 3 votes short of passing it. You know, we fell 2 short in Montana after we had the votes. You know, We're coming this close in Kansas to get it out of the House. In Washington, you've got the numbers in both chambers to pass it. There's some leadership issues. You've got 4 governors declaring a moratorium in their states, not on their watch. Will an execution go forward? We're living in different time. We've had 7 states walk away and abolish the death penalty in 8 years. We're living in a different time. This is not the pre-Furman moratorium period. When you look at the Gallup poll, it was 80% in support of the death penalty. It's down to 60. And when you throw in life without parole as an option, it gets to that 50-50 point. We're living in a different time with respect to the death penalty. About a month ago, I'm sitting in a room, and there are 4 people there. These are the survivors of that horror in Charleston back on June 17th. One of the women had covered over her 11-year-old niece. She heard the sounds that took her son's life. And she's thinking she would be next, and the child she was protecting would be next. These folks reported it was just the return of the gunfire that was so shocking. When we as Americans think of violent crime, we think, what could be the worst crime possible? It's hard for me to imagine a worse crime than going into a sanctuary and killing 9 saints as they pray after they have invited you into the circle of faith and the circle of worship. But these 4 people were resolute in the thought that they don't want death to follow this crime. And these 4 people are angry, are hurt, are wounded, are looking for healing and balm. They're disappointed in some responses in their faith community. They are struggling folks. But the one thing they don't want, the one thing that will not give them relief, is to take another life in balance for what they've gone through. We are living at a different time on this subject. And as we reflect on the court and as we spend this day, we are a fortunate folks, and the journal has brought together some scholars that I'm just anxious to listen to. I am anxious to hear the learnings and the teachings. I mean, these are folks that the Supreme Court has quoted. We got Professor Donohue here, and anxious to hear his report. It's old hat now. Rob Smith is a young scholar who's gotten a lot more attention than he deserves. Not really, but he's an incredibly dynamic engine of knowledge and scholarship. We've got young scholars and old scholars, and I can say Doug Berman is old only because we have some things in common. I'm still so much older than he. But I am just so blown away by the folks that Matthew, you and your team have invited to share with us this morning. I think there's going to be exciting discussion, exciting debate. I can't imagine, what Linda Malone has to say about, 13 years ago, I read an essay from Carol Steiker on American exceptionalism and the notion that that the death penalty is something special to us as Americans. And I dare say that article has aged in 13 years. I mean, we are in a different place. And, I think part of the question, part of the challenge is how responsive is this court to the international learnings and the international positions that have come forward? this is going to be an exciting day. I can't wait to get into it. So for me, I'm just glad to sit down. The Journal has brought together a tremendous day. Let's have at it. I am looking forward to joining you in the afternoon. But the first panel is going to be moderated by Neil Vidmar. And on that panel, we welcome Frank Baumgardner and Professor Donohue. So, Matthew, if there are other introductions, are you going?
I think that's all.
Thank you.
I think many of you know I've been practicing law professoring without a license for the past 25 years here at Duke, not having a law degree, but a PhD. But the other thing with this symposium that has, the reason I'm sitting here today is that I became involved in a Black Panther murder trial back in 1973. I had no interest in the law up to that point. It just totally, I testified briefly, tagging along with a colleague on jury prejudice, and just one thing led to the other and the other, and so forth. And in fact, as I'm getting close to the end of my career here after all the years, I'm involved in 2 death penalty cases, one in California and a federal case in Vermont, so this is all kind of tying things together for me. And just with those few remarks, because I do find it very interesting for all of us, we will start out with, John, you're supposed to go first.
Okay. Let's see if I can.
Sit there. So
Yeah.
I can see the slides.
Yeah, me too.
There's some way to turn this.
Yeah, go to the slideshow at the top. Very top.
There it is. From beginning. All right. Oops. What happened here? There we go. Wonderful. Wait, something is in my screen here. Well, it's a great pleasure to be here, and I just want to echo Henderson's comments. It's such a august group of people that it's a great pleasure to join you and meet some of you for the first time, although, of course, anyone who works in this area knows all the people in this room by reputation. Let me just start with a reference to Beccaria. The last few years I've spent time teaching in Italy, and it's amazing how what a revered intellectual he is. And at the age of 26, he actually set a lot of the intellectual groundwork that we see the Supreme Court moving to now. And in his 1764 treatise, he wrote that life imprisonment has in it all that is necessary to deter the most hardened and determined, and that the death penalty could not be a just expression of state power, since the death penalty is not a more effective deterrent. And in fact, he went on to suggest that it might actually undermine deterrence by making citizens callous to the taking of another's life with the example of barbarity it affords. Now, if you fast forward 200 years to America, in the late 60s, the death penalty was dying out as the number of executions dropped to near zero. Of course, everyone knows what happened in June 72 with the Furman decision. That was, a moment when it looked like the death penalty was going to go away, but it sort of came roaring back in a very uncomfortable way, even though many of the justices thought that their, measured response to the death penalty rather than a complete abolition would lead to its elimination, and it did have the opposite reaction. Many states that didn't even have the death penalty brought it back, and the number of executions rose. But as Henderson mentioned, it's a new time today, and the question is, what can explain only 2 death sentences in Texas in all of last year? It really is a remarkable change. And the only apprehension I have is, will the Ted Cruzes of the world somehow engineer this world in a way that brings it back the way it did in the 70s that was so, I think, harmful for the nation in many respects. One thing that I think is critical to remember, that many justices will say things that, Furman is, the Furman critique has been answered by Gregg. But if you look at the factors that led to the Furman decision and the Gregg response, the response in Gregg was, well, now that the states have adopted these new procedures, we can't say that the Furman critique will apply. But 40 years of empirical evaluation, I think, has sort of made the case that Justice Breyer articulated so forcefully in his dissent in Glossip. And if you look at the claims of Furman, the death penalty cannot permissibly be imposed if it's exacted with great infrequency, even for the most atrocious crimes, with no meaningful basis for distinguishing the few in which it is imposed from the many in which it is not, or that the 8th and 14th Amendment cannot tolerate the infliction of a sentence under legal systems that permit this unique penalty to be wantonly and freakishly imposed, or that the sanction cannot be so totally without penological justification. These principles have, in many respects, been ignored by many courts, and now I think they're being taken seriously. And I think that this passage from Atkins, in some ways, is the single most telling sentence in a number of respects. That Gregg versus Georgia had identified deterrence and retribution as the social purposes of the death penalty, and unless the imposition, and here's the key words, measurably contributes to one or both of these goals, it's nothing more than the purposeless and needless imposition of pain and suffering, and hence unconstitutional. And that language, measurably contributes, I think, is sort of a command to the scholars to come forward with statistical analysis of the and other empirical approaches to sort of lay the record straight in a way about the way in which the death penalty has operated. Of course, as we mentioned, Justice Breyer has articulated this very fulsomely and essentially used the structure embodied in that Atkins quote to catalog the extensive empirical evidence undermining the claim that capital punishment measurably contributes to deterrence or retribution. In that remarkable dissent, Breyer stressed its unreliability, arbitrariness, long delays, and unusual use. And of course, 2 months after the decision, a case that touched on something that I have worked on for many years, since 2006 actually, was the Connecticut death penalty battle. And in State versus Santiago, the Connecticut ended the death penalty. We thought finally, but there's some backtracking going on there. It was a very contentious 4-3 decision that said after the Connecticut legislature had prospectively abolished the death penalty, it would no longer be consistent with the Connecticut Constitution to execute the current people on death row in the wake of the prospective abolition. And it was a contentious 4-3 decision. And it's now being undermined. I thought we had won and it was over, but the prosecutors who are relentless in trying to overturn this decision have somehow managed to get the court to have to address it again. They said, we're not going to accept the 4-3 decision because one of the justices had to step down by mandatory retirement. And the hope is, on the part of the prosecutors, that the new justice will join the very contentious dissenters, and they'll end up winning that case 4-3. So I'm very hopeful that that does not happen, but it is an alarming development on the horizon. So in my world, I did spend a number of years. You mentioned Carol Steiker. She called me up one day and said, have you seen some of these claims that the death penalty is a great deterrent? Can you look at that literature? And I ended up spending like the next 2 years of my life looking at these studies that claimed this massive deterrent effect, and they all completely collapsed if you actually got the data and looked at what they had done. And I was so grateful that in 2012, the National Research Council unanimously trashed those studies, and with some strong death penalty proponents on that panel. But interestingly, when Breyer said, there is no credible evidence of deterrence, Justice Scalia jumped in and said, I don't know why he says it's not likely. It seems very likely to me that there's deterrence, and there are statistical studies that say so. And he sort of revived these studies that I had looked at so carefully. And interestingly, that disagreement on the deterrence question between Breyer and Scalia mimicked a previous exchange between Stevens and Scalia on the same issue in Bays versus Rees, where Stevens had said, again, no evidence of deterrence, and Scalia had criticized that. And I thought just Judge Richard Posner's very harsh critique of what he called the incoherence of Antonin Scalia in an article a few years ago, where he accused Scalia of, quote, motivated thinking, the form of cognitive delusion that consists of credulously accepting the evidence that supports a preconception and peremptorily rejecting the evidence that contradicts it. And I think that does capture, at least certainly in this domain, some of Scalia's thinking. And it's a very unappealing and dangerous trait in a judge, particularly in a matter of life and death. But to get back to what Scalia wrote in Bays, he supported his assertion that there was a deterrence by citing one law review article by Cass Sunstein and Adrian Vermeulen that was not an empirical study. It was more a law review thought piece. And right after Bays versus Rees, with Scalia citing Sunstein and Vermeulen that there was a deterrent effect, Sunstein joined my co-author Justin Walfers and wrote, in short, the best reading of the accumulated data is that they do not establish a deterrent effect of the death penalty. Yet in Glossip, Scalia once again cited Sunstein and Vermeulen in support. So I do recognize it's a for judges to look at empirical studies, but all you have to do is sort of read what Sunstein writes and how Scalia could cite him once again in the wake of Sunstein's criticism of that position, I think is a very harsh critique of Justice Scalia's actions in that case. Scalia went on this time in Bays. Remember, he had only cited Sunstein and Vermeulen, but he this time cited two other studies, which were statistical studies, but those were the studies that the National Research Council report had specifically said should not be used to inform discussion about the deterrent value of the death penalty. And again, am I being too hard on Scalia? He's not an empiricist, but I just went to Google and typed in the names of those two studies, and it brought up, lots of critiques, including something that I wrote with Justin Walfers called Uses and Abuses of Empirical Evidence, in which we cataloged an array of statistical critiques of those two studies. And just the simplest defect is that if you actually correct their standard errors with the completely state-of-the-art correction that is now uniformly recognized as appropriate, there is no statistical significance in their results. Yet these sort of zombie studies live on because they're out there, and Scalia cited them. Also, those two studies by Deschbach, Rubin, and Shepard and Zimmerman used a technique called instrumental variables. I won't bore you with what it actually means, but the NRC looked at those instruments and found them not to be credible, and the NRC report said, in general, the committee finds that the instruments proposed in the research are not credible, and as a result, this strategy has thus far failed to overcome the challenges to identifying a causal effect of the death penalty on homicide rates. So again, I think it's fair to criticize Justice Scalia for citing research that has been so thoroughly refuted. Interestingly, the Connecticut Supreme Court justice in dissent in the Santiago case also was making sort of extravagant claims about deterrence. Remember, in Connecticut, the legislature had prospectively abolished the death penalty. And so a number of judges said, well, we know there's no deterrent effect to killing these guys on death row now because nobody can get the death penalty going forward. So no criminal who's thinking about what to do has to worry about the death penalty. And yet the Chief Justice said, you know, I still think there's going to be deterrence value in killing these people on death row. And again, think of the Atkins standards. You must find that it measurably contributes to deterrence to make it a constitutional punishment. It would make the Atkins standard meaningless if a court could say, oh yeah, we think there's enough reason to believe that there's deterrence once we've prospectively abolished the death penalty, when you can't even identify deterrence when the death penalty is being actively used. In fact, if you look internationally, when there's a wonderful paper comparing Hong Kong and Singapore, where Hong Kong eliminated the death penalty in 1994, just at the time that Singapore thought the death penalty is a great tool of public policy and used it much more frequently than Texas in its heyday. And their rates of murder were always almost identical, and they remained almost always identical in the years after 1995. So I think one of the goals of scholars in this arena is to sort of give empirical content to some of the claims that the courts have made over time. And just to give an example, the court has said, within the category of capital crimes, the death penalty must be reserved for the worst of the worst offenders. And Justice Breyer stressed in Glossip that the court has sought to make the application of the death penalty less arbitrary by restricting it to this narrow category. And so when I was brought on to do a study of the Connecticut death penalty, I tried to see, can we actually give some empirical content to that claim? And so it turned out we had data on the 205 death-eligible cases that had occurred in Connecticut between 1973, when the statute was implemented after Furman, to 2007, when our data analysis started. And we asked our coders to evaluate their perceived egregiousness of the various 205 death-eligible cases in a number of ways. One of them was just saying, looking at the facts of this case on a 1 to 5 measure, how egregious do you see it to be? We also had a more nuanced scale where we took 4 factors of victim suffering, various victim characteristics, intent and culpability of the defendant, and number of victims, and came up with a 4 to 12 egregiousness standard. And here is the graphic that the New York Times actually did, and since their graphics were a lot better than mine, I'll show you theirs. But essentially what each of those boxes represents is one of the 205 death-eligible cases arrayed along this 4 to 12 egregiousness measure. And you can see a sort of a bell-shaped curve of egregiousness, and the red boxes are the ones that ended up with a sustained death sentence. And you don't see what you would have expected if the command of the court that it would be limited to the worst of the worst within the class of death-eligible crimes. and the Times points out only one of the 32 worst cases resulted in a death row conviction. And that's Michael Ross on the right side, who actually was executed. Santiago, which was the vehicle for reversing the Connecticut death penalty or adjudicating it to be unconstitutional under the state constitution, was a minority on white murder and was the least egregious according to the coders. And so what we went through here is just counted up how many cases were equally or more egregious yet did not get a sentence of death. And you can see the numbers are quite large, Santiago being the least egregious under this measure. 170 cases of the 205 were more or equally egregious, yet did not get a death sentence. Under this measure, 117. And it was really only one case, the Ross case, that could plausibly be thought to be among the worst of the worst. And so Breyer cited this Connecticut study and said, the application of the study's metric made clear that only one of the 9 defendants was indeed the worst of the worst. The remaining 8 were not. Such studies indicate that the factors most clearly ought to affect application of the death penalty, namely comparative egregiousness, often do not, yet the circumstances that ought not to affect application of the death penalty, such as race, gender, and geography, often do. Now, Thomas stepped in. I guess he was considering me to be one of the death penalty abolitionists who could not be relied upon. And he said the Donohue study, on which Justice Breyer relies most heavily, measured egregiousness of murders by asking lawyers to identify the legal grounds for aggravation and by asking law students to evaluate written summaries of the murders and assign these egregiousness scores. He said this exercise in some ways approximates the function performed by jurors, but there's a critical difference because the law students make their moral judgments based on written summaries. They don't spend hours, days, or weeks listening to the evidence detailing the crime and have an opportunity to assess the credibility of the witnesses, the remorse of the defendant, feel the impact of the crime on the victim's family, et cetera. I thought in some ways the critique, obviously there is a difference between the evaluation that my coders were doing, but Thomas asserts that relying on these studies to determine the constitutionality of the death penalty fails to respect the values implicit in the Constitution's allocation of decision-making. I thought that was a very misguided critique. We had a very particular goal in mind here, which was to see if the system was working the way the court said it should work. And while it's true that each of my 18 coders had less exposure to the case than a juror would have, they also had something that the jurors didn't have. My coders were looking at 205 death-eligible cases, while a juror is looking at one case. And also, I was screening out certain information from my coders that the jurors were very aware of. If a minority kills a white, the juror is sitting there very acutely aware of that, while my coders were not given that information as they were making their egregiousness determination. So while it's clear that Thomas highlighted a difference, he seemed oblivious to some of the advantages that my particular approach had that really was essential if you were going to do the type of analysis that we were trying to do. I also, as one reads the Thomas and Scalia opinions in Glossip, I'm just struck by the fact that they don't seem to understand the system, at least as I understand the system. Scalia writes, I would not presume to tell parents whose life has been forever altered by the brutal murder of a child that life imprisonment is punishment enough. Thomas mimics almost the same language. But very few parents whose children have been brutally murdered see the murderer executed. For example, in my Connecticut sample, 46 of the 205 death-eligible cases involved such a killing. So they could have gotten the death penalty for killing a child under 16, but only 2 of those 46 ended up on death row. And again, doing the egregiousness analysis, under one measure, 13 were more egregious than the 2 that got the death penalty. Under the other measure, 10 were more egregious. And so I'm just not sure if Scalia and Thomas understand that for the overwhelming majority, life imprisonment or less is all that the system will deliver, and picking out a few who will be executed doesn't reduce the pain, but in some ways increases it. Because remember, 46 parents are mourning the death of their child, and you're sort of elevating 2 of them as having a more egregious crime, when in fact it is no more egregious, and in some cases significantly less egregious. So I think that, again, understanding the way the system works would perhaps push Scalia and Thomas to a different resolution of this question. Again, Thomas, I thought, did a little unfortunate bait and switch where he took a broadside critique against the use of these empirical studies. And he said, the results of these studies are inherently unreliable because they purport to control for egregiousness by quantifying moral depravity in a process that is arbitrary, not to mention dehumanizing. And then he critiques, he sort of suggests by the correspondence of his attack on me with this attack that this is what I did, where he says, one such study assigns depravity points, and he goes through and, this is sort of meaningless numerology. But I did not do that. That was not my study. And so I thought it was sort of an unfortunate bait and switch argument to try to tarnish the study that he said Breyer was relying on most heavily with a critique that did not apply to it. Instead, I was applying a methodology that had been endorsed for over a half century with some of the giants of criminology, Sloan and Wolfgang, initiating this literature where they showed, and Daniel Kahneman, who won the Nobel Prize, a psychologist at Princeton, winning the Nobel Prize in economics, used the same approach in a study where they showed that there were norms about egregiousness. And indeed, while Thomas dismisses the arbitrariness analysis by saying, all of the cases I look at are horrible and certainly meet the standard for constitutional imposition of the death penalty, it's unclear if he understands that, of course, every one of those 205 death-eligible cases in Connecticut was a horrible crime, but the point of the analysis was to say it wasn't the worst of the worst that were getting the death penalty, and that seems to be the point that Thomas does not grapple with. And I think that at some level, Thomas and Scalia understand this, because whenever they try to justify the death penalty, they do go through and pick out the most egregious cases you can find. So they really do understand that some cases are a lot worse than others. In fact, everyone probably knows that in his famous battle years ago with Justice Blackmun, Scalia cited the McCollum case as the prototypic most horrible murder, and yet it turned out that McCollum was innocent. And of course, this represents, again, another reality of the death penalty, that in the most gruesome crimes, there's often the most emotion and the most desire to achieve a conviction, and increases the likelihood that injustice will be done. So I think Breyer cites some very compelling descriptive statistics when he says that in 1978, 183 inmates were sentenced to death. As of 2013, 35 years later, only about a fifth of them had been executed. 132 had their convictions overturned or commuted, and 7 had died of other causes. 6 remained on death row. So almost 80% of those sentenced to death in that period 35 years earlier were not going to be executed. So it's hard to see how this system could possibly be thought to, again, measurably contribute to retribution. And think of the enormous marshaling of complex and protracted legal process, with the strain on the parties, their families, the criminal justice system. So I think Breyer is quite right in saying this is a lot of strain and cost on the system for no obvious penological justification. And imagine what it would look like in the future if that pattern over that 35-year period were to continue. So last year, when there were only 49 death sentences in 2015, if the same percentages were to go forward, it would mean 35 years from now, only 7 would end up with an execution. You might say, well, if those were the 7 worst cases, that system makes sense. But as we've shown, it's not going to be the 7 worst cases. It's some random sample. So it does seem to be a freakish system. And if the prosecutors and the legislature were concerned about what the appropriate focus of attention might be, I think this graph shows it, that when the death penalty was adopted in Connecticut back in 1973, about 95% of Connecticut murders were being cleared. It's now, approaching 50%. And so I would rather solve murders rather than spend years and enormous amounts of money trying to get a few of the miserable defendants that have been convicted and could spend the rest of their life in imprisonment, sentenced to death and executed. Of course, Breyer also discusses race. There's a long history here, again, with many empirical researchers making an important contribution in McCleskey. But again, you see how challenging it is at times for courts to deal with that sort of statistical evidence. The trial court trashed the Baldus study for an intuitive basis, but the Baldus results were very solid, and it's easy, I think, for non-empiricists to think they've made telling critiques that often do not hold up. Again, if you're a motivated researcher or a motivated judge, you may take yourself down the wrong path. Scalia's, one of his first cases was the McCleskey case, and during the oral argument in that case, he said, well, what if you do a statistical study that shows beyond question that people who are naturally shifty-eyed are to a disproportionate extent convicted in criminal cases? Does that make the criminal process unlawful? I thought that shows such a narrowness of Scalia's thinking at the time. We were talking about race in the United States, a protected category in the history of this country, to sort of dismiss the concern of race and sort of belittle it in this way. Well, what about a study on shifty-eyed people? I thought that really showed a moral shallowness on the justice's part. So let me just briefly mention some of the evidence on race in the Connecticut litigation. So here you see the 4 categories where a minority kills a minority kills a minority, white kills a white, or white kills a minority. And you see in every case, the rate of capital felony charging was 85% when a minority kills a white, only 62% for minority, or 60% for white minority. So very substantial differential in these 4 categories. Again, the death sentencing rate about 12% when a minority kills a white, only 2% in this category, 4% here, 0 here. So we saw very large disparities, and what I tried to highlight here was that the average level of egregiousness under these various measures, oh geez, I've taken us in the wrong direction here, was quite a bit lower for the minority on white cases than, for example, the white on white cases. So under that 4 to 12 egregiousness, 8.2, 8.6 for white to white. Under the 1 to 5 measure, 3.6, here 3.8. So I thought the results of the study were quite compelling, and I was appreciative in many ways of the Connecticut Supreme Court's decision emphasizing that McCleskey was an incorrectly decided decision, and courts should reconsider McCluskey, because race continues to be a wound in the criminal justice system, and we make that wound deeper and more painful by continuing its application in the death penalty arena. Santiago also emphasized that unconscious bias is not fine. The reason that they said that was that in the trial that went on, Judge Sferaza, who was the trial court judge in the Connecticut death penalty case where I testified, said Donohue's results find statistically significant deviation when a minority kills a white. Donohue testified this probably reflects the tendency of members of the majority to be more empathetic to majority victims and less sympathetic to minority perpetrators with whom they identify least. The court concurs that this potential explanation is the most likely reason why this pattern occurs, but this explanation stems from a psychological phenomenon rather than some flaw in the legal system, and thus has no bearing on the constitutionality. So I found that an astonishing statement. Oh yeah, it's just unconscious discrimination, so you don't have to worry about that. And I was glad that the Connecticut Supreme Court justices attacked that view. I know you're all really anxious to see more regression results, but I think I'll skip over them in the interest of time here, other than to say, after we controlled for all sorts of aspects of the crime and stranger murder, strength of the evidence, gender of defendant and female victim, other measures of egregiousness and the judicial districts in which it occurred, still enormously statistically significant disparities in both charging and sentencing. And again, Thomas criticized Breyer's reliance on this, saying, well, the primary explanation that the Donohue regression analysis revealed for the gap was not race or sex, but the locality. And it's true that geography did play the largest single role, but he made that seem as though, well, that shows race isn't a problem. Race was the second biggest factor, and the idea that you can just dismiss race because geography is the biggest factor, I found really astonishing. Moreover, what does geography mean in Connecticut? It turned out it was one prosecutor in Waterbury who was very pro-death penalty, and he was actually forced to resign in 2011 following a federal corruption investigation. So you're getting a person with noticeably poor judgment making life and death decisions erratically compared to other prosecutors. And Thomas said, well, this is mere geography and therefore not a problem, even though race, again, came through powerfully, even after you controlled for geography. So I think Breyer's opinion and that of the justices in Santiago highlight the central role that empirical studies have played in the death penalty arena and make it more likely that if the standards laid down in Furman and Atkins are seriously applied, the case against the death penalty will be strong and effective. On the other hand, if the standards are effectively ignored or applied in what I think is the sloppy way in which Scalia and at times Thomas applied them, the death penalty will live on, maybe a lingering death. Okay, thank you.
Our next speaker on this topic is Frank Baumgardner, and we'll just let him take it over. Sit over here because you can see better.
I'm really happy to be here, especially to follow that excellent presentation and our introduction from Henderson. I want to recognize my co-authors who are all sitting in a Tar Heel row over here. Woody Graham is a law student at University of Richmond, and did a senior thesis with me that I'm going to report some of the data from his research. And then Kanesha, Arvin, and Colin are current students. And I thought I should use my UNC slides because if Marcus Page can't do anything in Durham, then at least maybe we can do something. So I'm gonna, I want to reinforce a little bit what John said. I think we are at a moment, and what Henderson said as well, we're at a moment where empirical evidence is really going to matter. And I think we need the evidence, but we also need the intuitively understandable arguments that even somebody who might be motivated to disagree with this evidence can't ignore. And we have to find a way to present the evidence that is so obvious, so overwhelming, because the evidence is quite overwhelming. The stuff I'm going to show you today about the geographical concentration will be my focus. It's amazing. It's incompatible with any kind of commonsensical understanding of equal justice. It just can't be justified. And yet, it has been justified many times. And we have a legal system where we're quite comfortable with local variation. And naturally, every unit of the American government, every local jurisdiction, we can't expect them to be absolutely the same. But is there any kind of limit to the degree of disparity that we might observe? We would expect some natural fluctuation. And what I want to show you today is fluctuation that can't be explained by random variation. It can only be explained by arbitrary self-reinforcement from some different starting point. So that's what I want to focus on. I'm going to give evidence about homicides. How many homicides are there across the counties of the United States for all the data that are available, which is 1984 through about 3 years ago. Every U.S. execution in the post-Gregg period. And we'll also compare that a little bit with ESPY data on historical use of the death penalty in the United States back to colonial times. And the evidence is going to show that executions are statistically uncorrelated with homicides, and that they're extremely concentrated in particular counties and in particular states. And even within states, executions are concentrated in particular counties, uncorrelated with their homicide rates. I'm going to describe this as a particular form of statistical distribution that might or might not be convincing to many lawyers because it's a complicated statistical argument. But a statistical power law distribution is a distribution that can only be explained by something that is self-reinforcing, such as the distribution of wealth in society. We know that extremely wealthy people have orders of magnitude more money, 10,000 times more money than I've got. And there's people with less money. Something that is randomly generated can't produce a distribution like that. We don't see any individuals, for example, your height, the height of humans is relatively randomly distributed. It's a bell curve. We see people occasionally who are 6'8". That's unusual. The average height is 6 feet or 5 feet 9, whatever it is, among males. We never see anybody who's 14 feet tall, and we certainly never see anyone who's 25 feet tall. If the distribution of heights in society were self-reinforcing, where if you're a little bit taller, you'd get even taller in the next generation, and it was self-reinforcing like that, we would see people who were 25, 30, 100 feet tall. We don't see that. We do see that in the distribution of income or wealth. Over the generations, families generate more and accumulate more wealth. And the wealthier they are, the wealthier they can become. So we know that the distribution of wealth is a power law distribution. What I'm going to show you is that the distribution of executions is a self-reinforcing distribution such as that. Okay? What that means, among other things, is that your chance of execution, not only is it arbitrary based on egregiousness, the decision of the prosecutor, it's more greatly determined by the history of how many people have been brought through that system in that local jurisdiction successfully all the way through to execution That's what determines whether you'll be executed. How many times your jurisdiction has previously greased the skids. If they've never done it, it's very unlikely that you'll be the first. If they've already done it, as in Houston, 125 times, it's not that difficult for them to do the 126th, okay? So I think that's an important argument. I'm going to go to the findings. They're extremely robust. We can look at the 50 states. We can look at the 3,000 counties. We can look at counties within any particular death penalty state. We can look at the countries of the world. We see the exact same distribution. It means that your likelihood of execution doesn't depend on your crime. It depends on the experience of your prosecutor in successfully executing people before you. Okay. This is the power law distribution. Okay? The average state in the United States has had 3 executions in 40 years. The median observation here. And here I list all the states in the District of Columbia in the federal system, including those that have had no executions. So if you take your hand to the middle of that graph, you get to the median American jurisdiction. That number is 3. So if the median American state has had 3 executions since 1976, we know that we don't have a death penalty system in the United States. We have it in a few particular jurisdictions. So Texas has had over 500 executions, whereas the median is 3, okay? And there's many states with 0. And those states with 0 are not only non-death states, okay? If we look at the 3,000 counties across the United States, only 474 of them have had even 1 execution. So that means that about 2,700 counties, the vast majority of counties, have never executed anybody in 40 years. Okay? On the other hand, Houston has executed 125 people. And I'll give you the top counties here. Harris County, Dallas, Bexar County, Oklahoma City, Tarrant County, which is Fort Worth. Bexar County is San Antonio, of course. St. Louis County, not the city, but the surrounding county. Tulsa, Oklahoma. Other counties in Texas, Arizona, Florida, and 1 county in Ohio, Cincinnati, Ohio. Hamilton County, Ohio is the only northern county. These are the only counties in America that have executed 10 people across 40 years. So all the other counties, there's 20 counties listed there. So that means that there's just 20 places in America where there's even a chance that there would be 10 executions across 40 years, 1 execution every 4 years. Okay? Now, the number of homicides is enormous. As a matter of fact, since 1976 in our country, there's been over 700,000 homicides cumulatively. So the number of, if we have 700,000 homicides, about 8,000 death sentences, and 1,420 executions, we know that execution is not the penalty for homicide. They differ by orders of magnitude, by 2 orders of magnitude. This is a simple presentation at the top. You see that there is 1 county that's executed 125 people. That's Harris County. They've had 1 execution. That's 1 county. They've had 9% of all the American executions, 3% of all homicides, and they're home to 2% of all Americans. And if you go down to the 20 counties that have executed 10 people or more, which includes, of course, Houston, they've had 35% of all of our executions across the country. They've only had 12% of the homicides in those counties, and they are home to 9% of the American population. That's only among states that have had the death penalty throughout the bulk of the period. So it includes as death states the states that recently abolished. It does not include as death states the District of Columbia, Rhode Island, or Massachusetts, which abolished shortly after in the early 1980s. And if we look at all 474 counties that have had any executions, of course that's all the executions, but it's only 63% of the homicides and 50% of the population among death states, okay? So not including others. I want to show you 4 maps. This is a map of where are the homicides. The red dots indicate proportionately the cumulative number of homicides since 1984, so all the data available by county. Obviously, it's in Los Angeles, Chicago, my hometown of Detroit, and in the corridor between Philadelphia and New York. Remember that when we look at county level data, New York is 5 separate counties. So each of the boroughs of New York is its own county in this data. If New York City were one county, I think that would be a bigger circle. Houston, New Orleans, and Dallas are present there. We don't put any of, there's no shading or any dot in counties with fewer than 100 homicides, okay? And the darker gray shading are those states that have not had the death penalty throughout the bulk of the period, okay? This is homicides per capita. So where is it most dangerous to live? It's most dangerous to live in New Orleans, or up the Mississippi River, up through St. Louis. You can see a ring of high violence areas up the Mississippi River from New Orleans to St. Louis. My hometown, Detroit, still maintains its presence. And then an area between Richmond, Virginia, up I-95 through New York City. Okay, those are the places of greatest violence. Notice that none of those are in the state of Texas. Okay, the state of Texas contains no county that has among the highest homicide rate per capita. The number of executions per 100 homicides is a reasonable estimate, I think, of how likely is it that your district attorney will seek and achieve a sentence of death, and furthermore, that it will be carried out, which of course is a different thing than merely getting a death sentence, as we know. The epicenter of that is not Houston, it's Brazos County, where I survived after 11 years of teaching at Texas A&M University in College Station, Texas. It turns out that's the epicenter of executions per homicide. They were on our list. Brazos County has 11 executions. It's in the top 20. You're not even aware of College Station, Texas, and Bryan, Texas as dangerous places, but they're dangerous if you're on death row because you may well be executed. The executions per capita then take place in that corridor in the mid-Atlantic states, St. Louis, and various places in Texas, Oklahoma, and Arizona. This is a map, though, of just the number of executions. Okay. The executions are well, I showed you the bar graph. Those are the same places outlined in the bar graph. They're in Texas, Oklahoma, St. Louis, Cincinnati, Florida, and Mobile, Alabama. Okay. The correlation between those 4 indicators is that homicides and executions are slightly correlated because highly populous counties have many homicides and also many executions statistically, although the correlation is only 0.3. So very, very low. The homicide rate is uncorrelated completely, 0.06, with executions. And the homicide rate and the execution rate are negatively correlated slightly at negative 0.26. There is no correlation, and if any, a very slight negative correlation between the likelihood that an individual will be murdered and the likelihood that a murderer will be executed. Okay? Now, again, these statistics are limited to death penalty states and to states that have, and to counties that have had at least 100 homicides. Because, for example, there's a county in Wyoming that had 1 homicide and 1 execution. So I'm not including those counties with the very, very low numbers of baseline homicides. These characteristics of this male distribution or extremely concentrated distribution continue when we look within individual states. So here I've simply presented Texas and Oklahoma. The distribution of executions across the counties of Texas is that Texas has, I think, 265 or 264 counties. 2/3 of them have had 0 executions, okay? And so the distribution, and that plot on the left shows all the counties that have had 5 executions or more. Remember, this is over 40 years, and there's thousands of homicides in many of these counties. In Oklahoma, similarly, there's fewer counties in this list, every county that's had even 1 execution. You can see its degree of concentration in Oklahoma County. Okay? And I have available, if you're interested, every state distributed this way. I want to give just a couple paired comparisons. St. Louis City has 300,000 people and 4,500 accumulated homicides. St. Louis County has almost 1 million people and 1,000 homicides over the same period. So St. Louis City, the central city of St. Louis, is a much more dangerous place for its population than the surrounding county, the suburbs, including Ferguson, by the way. On the other hand, there's only been, I say only, there's been 8 executions stemming from cases in St. Louis City, but 25 executions stemming from the surrounding county. And you can see the rates of homicide per population and execution per homicide. They're being quite different. And these are contiguous communities, St. Louis City and its surrounding suburbs. In the state of Louisiana, we can compare Jefferson Parish and Orleans Parish, both with 4 executions stemming from cases from those districts. New Orleans has had 7,000 homicides, but Jefferson Parish has had only 1,300 homicides. So very different rates of likelihood of a homicide leading to an execution within the same state. And similarly in Baltimore, we can compare the city with its surrounding county. And there are no executions despite almost 8,000 homicides in Baltimore City, and there's 4 executions out of not even 1,000 homicides in the surrounding suburbs in Baltimore County. So these are just examples. We could multiply them over and over again, but I think these are quite simple to understand. I want to compare a little bit about the geographical concentration of executions before and after Gregg. The left plot shows the number of executions by state in the 20th century before Furman, so from 1900 to 1972. The distribution of executions shows that New York State was the highest state leading executions in the 20th century before Furman. Okay? Of course, executions peaked in about 1935, and they declined from 1935 to 1965, at which point they reached 0. And they remained at 0 until 1977, so we can clearly distinguish the historical period and the modern post-Gregg period. So there's 2 things there: New York, Georgia, Pennsylvania, Texas, California, and then Ohio and other southern states. But you see some states in that first list that are not in the second list, namely California, Pennsylvania, and New York. The modern death penalty has become concentrated. That's the most important thing. Concentrated in a way that it had never been before, but also southern. Ohio is the only state in the north that has a significant, really a relatively large number of executions, whereas in the previous periods of American history, it was not uncommon to see executions in Massachusetts, in Pennsylvania, in New York, or California. Okay? Compared to historical periods, our modern period has seen greater concentration by geography, greater concentration in the South, greater concentration within certain counties, even within the death states. And we can calculate a statistical measure of that, which I've done there, but I think more importantly, we can see an increase in the concentration of the death penalty throughout the entire period. But also, as we look at the period from 1995, 1996, 1998, every indicator of the use of the death penalty reached its peak around that period in the mid to late 1990s. Since the mid to late 1990s, the number of executions, the number of death sentences, the number of states carrying out an execution, the number of counties carrying out an execution, or an index of public opinion, which I could explain, but I think that's for a different talk, have all declined. And what I've done on the right-hand scale there is scale each of these indicators at a value of 100% at its maximum value, so that you can see how much have they declined as a percentage from their maximum. And they've all declined by 70 or 80%. The number of states executing in 1998 was 20. It was 6 in 1995. The number of counties declined, I think, from 74 to 22. The number of counties that carried out an execution. Right? The number of executions itself went down from 98 in 1998 down to whatever the last number was, 26 or something like that. So it's down by 70%. Okay. Now, this is the part where I may lose you, but I'll go quickly over this. If we look simply at the distribution across the states, the same data that I showed you with Texas going, having over 500 executions, and we plot this as on a scale, which is a logarithmic scale, so that the distance between 5 and 10 on this graph is similar between the distance of 100 and 200. Anyway, the distance between 1 and 10 is the same as the distance between 10 and 100, or 100 and 1,000, a logarithmic scale. The numbers plot on a straight line, suggesting that the correlation between them is mathematically equivalent to a linear relationship to the exponent. Okay, it's a power law relationship. We look at the 50 states, we see an extreme outlier. There's two parts to a power law. One is that there's an extreme outlier, the equivalent of a human who's 140 feet tall, somebody who's very, very wealthy. But the other part to a power law is that most of the cases are clustered at 0. There's a huge number of cases that have no execution. And whether we look at the states or we look at the counties, there's 3,000 counties. Most of them, 2,700 of them, have fewer than 1 execution. There's a county with 125 executions. Okay, so this fits a power law distribution as well. Within the state of Texas, it fits a power law distribution within that state. Within the state of Oklahoma, we see that it fits the same distribution. Across the countries of the world, since 2007, we've been able to calculate the numbers based on Amnesty International reports. The number for China is an estimate. Okay? China is the outlier there. Then Saudi Arabia, Iran, I think, and the United States comes in about 4th. Okay? But the distribution of executions across the countries of the world fits the same statistical model, which is a model consistent with the idea that if you've never done it, you never will. And if you've done it a lot, it's easier to do that next one. It's what Lee Kowarski at the University of Maryland calls muscle memory. You get good at it, or you never develop the habit. It's like an addiction. Okay. So what does this level of geographic concentration imply? It's not consistent with the model of decision-making with mutually canceling out error terms. It's not consistent with the model that says 5 independent decision makers, the district attorney, the defense attorney, the jury, the judge, the appellate, overviews, reach independent decisions that might cancel each other out. If that were the case, and if the egregiousness of homicides was randomly distributed across all homicides, which I think we can assume that statistically, if the other decision makers were mutually independent from each other, rather than mutually embedded in the same historical context, then we couldn't possibly observe a rich gets richer process. We would only observe a bell curve type of distribution. So now what other types of things generate power law distributions? If you're going to make a new website, you're not going to link to Frank Baumgartner's website. You're going to link to google.com. You're going to link to a website that's already powerful. The distribution of links on websites across the entire World Wide Web is a power law distribution. The distribution of size of cities is a power law distribution. The distribution of height is a random distribution. Things that are statistically random generate bell curve distributions, and things that are statistically associated with what we call preferential attachment or rich get richer phenomenon generate what we observe with the death penalty. Why would the death penalty be a rich get richer phenomenon? I think it starts out with some general parameters of, are you a southern state? Do you have some level of racial threat, some minority presence which is significant enough that the prosecutor has some incentive to worry about that racial threat hypothesis? Are there enough homicides? But, you know, Atlanta, Georgia has a lot of racial threat. It's got a lot of homicides. Tallahassee, Florida, it's got a lot of homicides. It's got a lot of racial threat. It's in the South. It's not a bunch of liberals. Why Houston and not New Orleans? New Orleans has got the epicenter of our homicides. Its homicide rate is similar to that of Belize. It's similar to that of Honduras, okay? It's 10 times higher than the average in the United States. It's a very violent place, but they're not the epicenter of executions. Houston is. And what I want to put out to you is that there is no logical explanation for that. It's only a random start that then became self-reinforced through local expectations rather than anything correlated with the degree of violence in that community. As a matter of fact, the degree of violence in the community is uncorrelated, perfectly uncorrelated with the number of executions. So I'll stop right there, and hopefully we can have some discussion.
We've got some time left in terms of our schedule. Do you have any questions? Oh, yes.
Excuse me. Are there any academics now coming out with dismiss some of these prior studies, but are new people coming out with new studies that support the death penalty anyway statistically? And if so, what's their angle?
It is interesting that there are people who continue to make those claims, but it tends not to be new scholars. It's sort of the old people, like John Lott, for example, continues to say that the death penalty is a deterrent even after the National Research Council report, and you can find individuals who come out and challenge anything. Let me just show you one example from my experience in the Connecticut death penalty regime. And so this was an expert named Stefan Michelson, who was hired by the state to oppose my report. And he wrote 8 500-page reports because we kept discrediting each report, and he'd write another one. He was getting paid $500 an hour. At the end, he got $1.5 million to attack me. And we thought it was all over in August when Santiago sort of struck down the death penalty. But then when the prosecutors revived it, Michelson came out with a new report, so the battles continue. And what he did was he tried to criticize my finding that when minorities kill whites, they're charged with a higher rate. And so he mucked around a little bit with the regression. Now, this was the first time in 8 years where he found a regression that did not generate a statistically significant effect. And basically for you econometric jocks, you can see here that this is not statistically significant, and this is the minority on white case. So it was still 10 percentage points higher rate of capital charging, but not statistically significant after he mucked around a little bit with my regression. And what he did here was interesting. He dropped out, remember I showed that there were 4 racial categories. He dropped out 3 of the 4. And so what I did was just restored all 3. And he had gone through and must have run thousands of regressions, changing the judicial districts that were included. And one thing, if you work in this area, you realize that as you add in or subtract different explanatory variables, you can sometimes bounce the regression results in one way or another. And if you array them so that you always bounce it one direction, you may lose statistical significance. So I just said, well, again, put in all the racial categories, and then use all the judicial districts of Connecticut, and then you get back the very large, percentage point difference that I had showed earlier, and still statistically significant. And then I added in all of these things about strength of the evidence and controlling for, female victim, was it a stranger murder, was there a prior prison sentence, and the results grow very dramatically. So again, it shows part of the problem that courts have when someone comes in like Michelson, who mucks around with the regression and he manages to find one regression that goes their way. And again, if you get a motivated judge, he said, oh, well, look, the results go that way. So it is a difficult task for certain judges and also for legislators, because they get pummeled with the apparent study that goes the other way. But that's one reason why I think things like the National Research Council reports can be useful, where you bring in a body of experts. And that particular study, as I said, had both some very strong pro-death penalty voices. James Q. Wilson was on that panel, and they unanimously rejected the deterrence claims.
Yes.
Professor Baumgardner, I was wondering if you had done any analysis of whether the pre-Furman concentration of executions was correlated to the homicides.
I can answer that simply, no, I haven't. We don't have county level data on homicides before 1984.
Yes, Tom.
So if money weren't an object and you could design a study that would be the most statistically strongest statistical model, what would it look like and how would you go about it?
I guess in my opinion, and I should say I've done these studies all with zero funding. There's no funding at all. If I could do it on a larger scale, I'd do exactly what my colleague John did for Connecticut, but do it for more states, and which I think is pretty much exactly what Baldus did for Georgia. Yeah. And so I think those are the state of the art. And I do think that the results of the Baldus study are revealing, because they were unsuccessful, in spite of the fact that I think to any unmotivated social scientist, they're very, very convincing. Whether that's a good legal strategy is a different question. It's a great social science strategy.
Yeah, again, it's interesting. If you read the district court decision, you would think the Baldus study was just all hogwash. But the academic consensus on the Baldus study was it's very strong. And to the extent that you can look to other jurisdictions, the results buttress the Baldus findings rather than undermine them.
Yes.
I have a question for you, John. So I've been thinking about your presentation, and particularly Justice Scalia and therefore Thomas's response to some of the statistical results. So I brought up in mind kind of a theory of delinquency by David Matza and Gresham Sykes, the techniques of neutralization. Delinquency theory try to explain how people justify engaging in their bad behavior. And they identify 5 of them: denial of injury, denial of responsibility, denial of the victim, appeal to a higher loyalty, and a condemnation of the condemners. See some of that, it appears to be in that. But if you think about McCleskey, again, as you mentioned, Scalia was a new justice. You had Powell there, and so I apologize, I can't remember, was it 6'3" or 5'4", I forget.
5'4".
5'4". So again, the young Scalia was not alone, right? We have Rehnquist on the court, who I think, Scalia was carrying that mantle. And so I'm just curious, when you kind of broaden that view to some of those other justices, I mean, do you think there's still some of that same way they kind of do, I guess it's cognitive dissonance there? I'm just curious if you kind of can broaden the frame to some of the other justices. What are your thoughts from what you've read and what you would speculate?
It is interesting as you look at the judges and justices who are seem to be straining to endorse and support the death penalty. There are an array of different strategies that are used. Some, I think, just say, look, this is one of the contentious issues, just leave it up to the legislative process. But some have a deeper motivation. And Scalia actually wrote an interesting article that was published in some religious journal where he talked about his views on the death penalty. And he just really is a great and passionate believer in the death penalty. And it was interesting because it was vintage Scalia in a way where he was so self-contradictory within the contours of his own article, where he started off in saying, I'm going to talk about my views on the death penalty, and I think it is a moral thing, but none of these views have any bearing on my actual performance on the court, because that's a legal matter, and I would separate my own personal views from my legal obligations. And then he goes through this long discussion about the Catholic Church has denounced the death penalty as an immoral punishment. And he said, well, I disagree with the church there, and I think it is a moral punishment, which is good because otherwise I couldn't endorse it, where he had just said, his own views would not matter. So there does seem to be something that motivates people powerfully to personally endorse the death penalty, and I think that gives it an energy that maintains itself. Now, interestingly, you mentioned Powell's role because, again, one of the great ironies is shortly after he stepped down from the court, he said, yeah, I got that one wrong. I should have gone the other way. And that single belated switch could have changed so much. And indeed, so many of the problems that we see in Ferguson today might have played out differently if the court had taken a stronger stance back in 1986 in thinking about race in the criminal justice arena. Now, I do think one concern that clearly was manifested in the McCleskey decision was the concerns that if we say that race is problematic in the death penalty, isn't the next case going to be the whole criminal justice system has that problem? And that's true. But I think one thing that could have been said, and a lot of people seem more willing to say this today, is that death is different. And interestingly, again, ironically, Scalia quoted Kant in his Glossip dissent, which was striking because if you remember his earlier denunciation of references to Europeans, and he said, the European tradition is so completely different than the American tradition that it's irrelevant. And then here he is quoting Kant. But Kant felt that death is so different that the only way you could give the appropriate punishment for killing someone would be to give the death penalty. So it's so ironic that, again, Scalia is citing both a European, someone who has a view of the death penalty that at least suggests death is different, and you can proceed differently with death than you need to do with the criminal justice system in general. And then finally, again, I think it should have been ironic for Scalia to be citing Kant, because we have 14,000 murders in this country every year. We had 25,000 in the early 90s. But as we see, the handful of people that get the death penalty is so wildly disproportionate that citing Kant for what we should be doing in the death penalty arena in the United States, again, seems wildly inappropriate.
Yeah, we'll just add a couple things to that. One is it's so interesting, and a lot of the legal or the judicial response to this is kind of like, I only see what's before me, I don't see what's not before me. So what they're not seeing is all those egregious homicides that don't end up with a death sentence. And I think that's an intellectual blind spot that I think it's up to us to firmly bring to the court's attention. But I do think that this panel has been very interesting, but also focused on geography and just a few things, whereas Justice Breyer's dissent, I think, properly raised a catalog of issues. And I think when you think about if you had unlimited funds, it's not only to do this study right, it's also to point out many other flaws. And I think that now we do have a moment now with 40 years experience and 700,000 homicides that have taken place across our country, unfortunately. And we can assess whether we have reached the promise of Greg. And is it reserved for the worst? Is it applied in a way that, you know, you can expect death if you commit one of the few crimes for which death is supposed to be reserved? And we can pretty firmly answer those questions. The answer is no. You can't expect a death sentence. If you do get a death sentence, there's a 65% chance it'll be overturned on appeal. Even if you get a death date, you get a warrant, chances are it'll be overturned. So it's, there's so many flaws that are empirical flaws, not conceptual flaws, but flaws in the administration of the system that I think we can enumerate them and catalog them in a way that should be shocking to the conscience of anybody. Even the most motivated supporter of the death penalty system, whose response might very well be, well, then let's fix it. But we have 40 years of experience that suggests it's difficult to fix. So I think that we really want to enumerate and catalog all of these flaws. But they have to be done right, and it has to be done one at a time, and there's a lot of them, including lethal injection and methods of execution. There's a whole other area where there's a lot of troubling empirical findings coming out.
The social psychologist in me wants to, I can't figure out how I would do this study, but I think the culture of the prosecutor's office, I mean, some of the work you're showing, it's in particular areas and so forth, and there may have been a culture of this. I'm not sure it's correlated with rates of homicide or anything else, but it would just be, it's worth thinking about how, especially when we have elected prosecutors. Well, my predecessor did this, and they feel that kind of pressure that you just don't know how to do it. I'm not sure how I could do the study, but it's certainly one I think it's worth thinking about. Yeah.
Thought, Professor Vidmar, and I guess this is mostly for Professor Baumgartner. There's been a lot of research in behavioral law and economics recently that points to this idea that we, when we're making decisions, create fallible heuristics to basically replace like more rich reasoning. And I was curious if in your studies of the different counties and prosecutors' offices, especially those that have a higher rate of pursuing death penalty cases, did the prosecutors there start to develop sort of shorthand for what is a death penalty case that was, a fallible heuristic, really, that doesn't apply the rich reasoning that they would have otherwise put into place after they'd gone through the process a few times?
I haven't done those case studies, but I actually have a student right now who's calculating for the, we got from the Center for Death Penalty Litigation in North Carolina, a list of every death-eligible crime in North Carolina since 2000. And you'd be surprised to know that if there's about 500 or 600 homicides, there's about 450 to 500 death-eligible homicides in North Carolina. So most homicides in our state are death-eligible, the vast majority. So the CDPL is, made aware of those death-eligible cases, and then they may or may not go to trial. And so we can calculate, and it turns out 2001, I think, was the date, or it might have been 2000, when the prosecutors in North Carolina were given discretion not to seek death if it wasn't appropriate. Previously, they had to. It was unique at that time. They had to seek death every time. And so we can see this dramatic decline in the rate at which prosecutors seek death. But we can also predict that using a regression with time, and then we can calculate the excess rate of seeking death for each prosecutor. So some seek it more than you would expect, some seek it less than you would expect. So I think that's the next step in this research, would be to then investigate what is it about Kenneth Honeycutt in his office, who had the lapel pins with the little noose insignia. And he is indeed one of the prosecutors that was way statistically an outlier compared to what you would expect statistically from how many death-eligible homicides took place in his district and how many he prosecuted. The other one was Joseph Freeman Britt, the prosecutor who was listed in the Guinness Book of World Records, and who put Leon Brown and Henry McCollum on death row. So we can do those things, and I think that's probably a next, that might be one of those things you do if you have a lot of money.
Yeah, well, I just wanted to add one other thing, and I think we've got to take a break. I'm getting the thing is how much the politics of this plays out in the individual prosecutors and the election cycle and so forth. And it really does seem, because in fact, I know a couple of prosecutors who are really very decent people I've worked with, but in talking with them about this, it's just, we can never make a connection because they just kind of go off and aren't willing to say, well, hell, I may be voted out of office the next time. So I think there's a real problem with that.
Yeah, I think if I could add to that, whether your question was about these inaccurate heuristics, one of the most interesting things about inaccurate heuristics is that members of Congress in the United States believe that they might not be reelected. It's a 95% chance they're going to be reelected. They're always reelected. And yet they live in fear that they could be taken out. Yeah. And I think there is an irrational understanding about how popular the death penalty is for a district attorney, more so than it probably really is. But that's a heuristic that they are using.
If I could just say one thing here. Again, I think the more the system becomes transparent, the more you dislike the death penalty. I think if you have a very cabined view, it makes much more sense than a more holistic view. The study in California showing that California spent $4 billion to execute 13 people over a 30-year period. When you think, we know how to use $4 billion to reduce the crime rate, and it's not by executing people. So the lives that we could have saved or improved with $4 billion were just sort of thrown away. And I think if people had that awareness, instead of the sort of Thomas or Scalia view of giving you a really vile case like the recitation of the McCollum murder that really wasn't the McCollum murder, you hear that, and it does generate a visceral response. But what we need, and what I think the empirical and other literatures are developing, is a more comprehensive assessment, which, if that message could come across, I think it would change many minds.
There's been a cultural thing on the defense side, which is that people that I know in this community don't like to talk about horrific crimes. That's for prosecutors. But we have, as I've mentioned now 3 times, 700,000 homicides in this period. And a lot of them are horrific, and which did not lead to even a capital prosecution. And I think that's been a no-no for the defense community, to talk about those horrific crimes, because we just don't like to talk about horrific crimes because we think it works against us as a community. And I think that's probably a mistake.
I've gotten a couple signals. We're about 5 minutes over to take our break, so let's take about a 10, 15 minute break. This has been good.